Hey, what's up, everybody? My name is Sean Flynn, and this is my final presentation for the legal aspects of kinesiology. So, for my facility background, I chose a university athletic department. I currently work at a junior college, so that would be fine too. Any college level, junior college, Division I, Division II. I'd love to become a head football coach and then eventually become an athletic director of a university or junior college. So using this facility was an easy choice for me. By doing this, it's going to give me some insight into what these departments go through with legal issues. It seems like every year more and more universities and mainly athletic programs get lawsuits filed against them. So I thought there'd be tons of information on this as well. The first legal issues that most schools see is negligence. The example that I found was Cody versus the University of Eastern Washington. A pole vaulter got injured. They didn't have the right protocol for head treatment and head trauma, which is becoming a bigger and bigger issue. So she sued the school for negligence. Had they had safety measures in place for head injuries, she could have had a near fatal brain injury prevented. So that was something to take into consideration. There's a lot of that with football as well. Another legal issue that I saw a lot of was risk management issues. So Verney versus Aramark et al. Was a big lawsuit. Basically, a spectator went to a NFL football game, was intoxicated under the influence when they left, drunk driving, hit a car. He was arrested for vehicular manslaughter, but the family of the car that got hit also sued the stadium for letting him leave under the influence and providing him with alcohol throughout the day. So something to take into consideration because tailgating is a big deal at a lot of universities. Football games, basketball games, baseball games, you name it, there's tailgating. And although they're not inside the stadium at the time of the drinking, you're still responsible for them if they are on your premises. Labor disputes is another big issue that's been getting bigger and bigger in the NCAA, and using the likeness of athletes. O'Bannon versus the NCAA. Ed O'Bannon was a basketball player at UCLA. They used his likeness on the cover of a video game as well as selling jerseys and whatnot. He ended up suing the NCAA and won the lawsuit. There was another one, I believe Sam Keller was a quarterback at the University of Arizona State, and he sued EA Sports, which created a video game of college football, and they used his likeness as well as a lot of other college players, and he won as well. So something else to take into consideration is player likeness and individual likeness of an athlete, and not really making money off of their likeness. So now into risk management. The three cases that I found, the first one had to do with premise liability, which I touched on a little bit earlier, but this one was Benjamin versus the state, in which Thomas Benjamin purchased a ticket. He went to the hockey game. After the first hockey game, there were some open seats. He moved to another seat. There's a fence surrounding the rink, but it didn't cover the complete circumference of the rink. A puck went errant, hit him in the head, and fractured his skull. So he sued the stadium or the university for not having foreseeability and premise liability. This case could have been avoided just by simply recognizing that the fencing did not go all the way around the rink, and adding more fencing, 10 to 15 feet on each side, could have completely solved this issue. Recognizing things like this would help in my future career, because no matter what sport it is, baseball, football, basketball, hockey, for example, there's always a chance of a ball going errant or a player flying over a bench in basketball. Because everyone wants to be so close to the action, there needs to be some kind of a protective barrier. So this was a really good case to figure out how to mitigate the risks. The next risk management plan, or the next risk management suit that I found, was a lack of an emergency plan. And Mogabgab versus the Orleans Parish School Board. Although this was high school, it can also be related to a junior college or a university. There was a conditioning practice. It was football, and the defendant collapsed while running sprints. there was no training staff there. The coaches had no CPR, no first aid training. They kind of didn't know what to do. And so all they did was have two players carry him off and put him onto the bus. And they didn't return until after practice, which was 2 hours late after his collapse. And he ended up passing away. Just by having a simple emergency action plan, they could have prevented this kid's death. I think that every athletic department should implement an emergency action plan based on cardiac arrest, based on injury. They should always have an athletic trainer, at least one at the practice with a walkie-talkie or a cell phone, or some means of communication to emergency response teams and whatnot. I also think that at least 2 or 3, if not all the coaches, should have some CPR and first aid training in the case of emergency as the one presented in the case. You could prevent a lot of harm. Excuse me. The last one, probability of injury, Kleinecht versus Gettysburg College. The mother of Drew Kleinecht in this case he was a lacrosse player who suffered cardiac arrest while at Gettysburg College during a practice. Kind of the same thing as the Mogabyab case. There were no trainers available. The nearest training facility was 250 yards away, in which they had to get over a fence. There was no telephone, there were no walkie-talkies, and no one on the field had any type of CPR or first aid training. Again, this could have all been taken care of by simply having people CPR certified, which is very easy to get, first aid training, also very easy to get, as well as just having a couple trainers at each practice. There's more than enough trainers between student trainers, head trainers, assistant trainers to take the responsibility of each practice. I think with organization of practices and making sure that they're not overlapping to where there's not enough trainers is huge, and that would be something as an athletic director that I would like to apply for all sports across the board to better mitigate the risks of such incidents. Okay, so for employment laws, Title VII is a big one. Title VII of the Civil Rights Acts of 1964, and the main one, or the one that I'm focusing on here, would be gender discrimination. Purdue versus City University of New York. This case basically goes into a former women's basketball coach suing her former employer, which was Brooklyn College, saying that she didn't get paid equally to her male counterpart despite them doing the same work under the same condition. Basically, they had all the same responsibilities, all the same experience, and she was getting paid significantly less than her male counterpart. She ended up winning the case, and the school ended up having to pay her close to $1 million in awards. So this could have very simply been taken care of by simply making her sign a contract, or by equal pay. The Equal Pay Act is a big deal. They clearly didn't take it that seriously, but they should have. It would have ended up saving them $1 million. So another case that came up was Stanley versus the University of Southern California. This was basically the same thing. She said that she had the same responsibilities. Marion Stanley said she had the same responsibilities as the male counterpart, which was the men's head basketball coach. However, in this case, the University of Southern California won the case. The court ruled that because he had 14 years more experience, that he deserved to get a higher pay grade. So all things being equal, whether male, female, it doesn't matter. It doesn't matter the gender, the race. If the duties, responsibilities, experiences, and skills are all the same, then the pay should be as equal as possible. I think by making people sign contracts with such verbiage in the contract as to what they're going to make for what responsibilities is another way to mitigate these issues. And yeah, so moving on. Title VII also covers racial discrimination. Racial discrimination is a big deal, especially at the NCAA level, in my opinion. In 2016, for example, there were only 11 black head coaches of the 128 Division I teams, which is only 8%. That's not enough, and I think a bigger problem is that the positions of power at universities, such as university presidents, athletic directors, head coaches, associate athletic directors, those are held by whites between 88 and 97%, which could lead to hiring like people. I think that this could be resolved by simply adopting the NFL's Rooney Rule or a version of it. I personally think the Rooney Rule is a great rule. I would like to see more than just one person interviewed a minority interviewed. I think that if I was in charge, I would try to create a rule in which 3 to 4 minorities had to be interviewed for each position. Another thing that I would do is have a blind interview where the interviewers can't see the interviewee, so that you have to solely base the merit of the interviewee on what they say, how they interview, their resume, and whatnot. And you can't put a name with a face or gender. It's just completely blind, and you pick the best candidate. The Due Process Clause is another employment law. It's no person shall be deprived of life, liberty, or property without due process of law. This case was Price versus the University of Alabama. In this case, Mike Price got fired for inappropriate conduct while representing the school at a charity golf event. He tried to claim that he had no hearing or due process, and so they took away his due process. But because he did not sign a contract with the university before this incident, he had no valid property of interest, and so the DPC did not apply in this case. The best way to avoid due process law and allegations would be to fully understand the constitutional law. So that's a big deal, is understanding the ins and outs of it all. And in all contracts, termination of contracts or sanctioning of an athlete employee for something such as misconduct, the university must make sure that they are respecting the law and not depriving employees or athletes life, liberty, or property of interest. Okay, so before I get to the application in faith, in this class, I learned so much about what I'm going to apply in the future. A lot of the cases that I read, I just felt like, had they paid attention to detail, a lot of them could have been completely avoided. And so building from the ground up and making sure that everything is encompassed and not getting lazy in certain aspects, like for example, the Benjamin case in which they just didn't put 10 to 15 more feet of fence and the kid wouldn't have had a fractured skull, they would have never had the suit. I mean, that's pretty simple to me. If you're going to put up a fence, what's 10 or 15 more feet? It's saving you a lot of money in the long run. I learned how I would love to give equal opportunity in interviews for all open positions, trying to get more minorities positions of power and whatnot. So I learned a lot in this class. The 3 quotes that I chose are here. They basically all say the same thing. It's just put others before yourself. So I'm going to treat my employees equal. I'm going to treat them better than I want to be treated in return. I think that employees are they do the work, they do the legwork, and so they should be treated fairly, whether you're above them or under them. I think that everyone should be treated the same. And to do nothing out of selfish ambition or vain conceit, rather in humility, value others above yourselves. So that's perfectly summing up exactly what I just said, and that's one of my favorite quotes from the Bible. Lastly, if I was ever faced with a decision that may be legal but against my personal beliefs, I couldn't think of any off the top of my head, but if I was ever in that position, it's kind of hard to say, because without knowing the situation, I don't really know how I'd handle it. I mean, I guess I would just put my trust in God and hope that He guides me in the right direction. I think that without knowing the consequences and whatnot, I would put my personal beliefs before a job. But again, without being in the situation, I don't truly know. I would just, pray on it and hope that God guided me in the right direction. So, thank you for watching my presentation, and good luck to everyone out there.